Hello viewers, welcome to today's session of Nigerian Law Documentary. On today's session, we'll be going into the realm of taxation. Particularly, we'll be looking at the clash of interests with regards to the taxing power of the federal government and state government in respect of VAT. It is important to note that VAT is another name for sales and purchase tax, in the sense that both sales and purchase tax and as well as the VAT levy the same tax on the same tax base, which is the same goods. So they are just the same thing. So any attempt to make a distinction between these two is like trying to make a distinction without a difference. So why is it important that the disputes between the state government and federal government should be resolved? Why is it important? Why is this issue causing national concern? It is causing national concern because if both the state government and the federal government are allowed to levy tax on the same goods, it will amount to double taxation on the citizenry, and this will impede the growth of business, in the sense that it will cut down the profits that business are making, and this is also against international best practices and standards. So it is very important that these issues is resolved with immediate effect. Well, the cause of this dispute itself can be traced back to the 1960 constitution. The 1960 constitution gives the federal government power in the exclusive legislative list, particularly at paragraph 38, gives the federal government the power to levy tax with respect of purchase and sales of goods. However, this particular powers was not included in the 1979 constitution and as well as the 1999 constitution. So does that mean the federal government no longer have the power to levy tax with respect of these goods? This was the argument that was raised in the case of A.G. Ogun and Aderugba. The case was brought to court by the Association of Wholesalers of Beer. They brought this action challenging the propriety and validity of the tax law that was passed by the Ogun State government, which levy the same tax on the same goods that was initially levied by the federal government, claiming that the law is inconsistent with the taxing powers of the federal government. So they pray that that particular law should be declared null and void. However, it was the argument of the learned Attorney General of the Ogun State that it is the intention of the legislature, by intentionally omitting that particular item 38 of the 1960 constitution in the subsequent constitution, even in the present constitution, it means that the legislature wants that particular item to be at the residual powers of state government to levy. That was a clear intention to reserve that particular items to the state government. However, Bello, Justice of the Supreme Court, in a very logical judgment, what he did was to marry some sections of the constitution and come to a conclusion. He opined that though the federal government, by section 16 of the 1999 constitution, the constitution gives the federal government power to harness and control the economy of the federation. However, that is not exclusively to the federal government, as subsequent provision of the constitution, particularly paragraph 18 of part 2 of the 1999 constitution, which gives the state government, the state house of assembly, the powers to make law with respect of industrial, commercial and agricultural development, and as well section 7 sub 3 of the 1999 constitution, which gives the local government powers to make economic plan for the development of their area, and also first schedule of the 1999 constitution, which gives the local government powers with respect of items like shops, kiosks, laundry houses, restaurants, bakery, food, etc. So the implication of this section is that the local government and the state government also have a share in the control of trade and commerce within their jurisdiction. Paragraph 61 of the exclusive legislative list of the 1979 Constitution, which is paragraph 62 of the 1999 Constitution, which made use of the word in particular when it was listing those items that the federal government can levy tax on. It made mention of the word in particular, and sales and purchase of goods are not mentioned there. So therefore, the powers of the federal government should be restricted to the items that were listed in that particular list. So the federal government do not have power to levy tax outside of items listed under paragraph 62 of the exclusive legislative list of the 1999 Constitution. So after making this analysis, the learned Lord made a general rule that the state governments have powers to levy tax with respect of goods that are within their jurisdiction. That is, goods that are intra-states, while the federal government have powers to levy tax with respect of goods that are imported, exported, or goods that are interstate, goods that are transported from one state to another. So therefore, state government have powers to levy tax with respect of goods that are produced within the state and consumed within the state, while federal government have power with respect of goods that passes or are transported to other states and with respect of import and export. So in response to this judgment, the National Assembly quickly passed the VAT Act of 1993, and the purpose of that law is to make sure that all goods, whether interstate or intrastate, falls within the taxing power of the federal government. So the question is, did this act achieve that goal? It is my contention at this point that no, it didn't achieve that goal. In fact, it led to a situation of double taxation where both federal government and state government are levying tax on the same goods because the VAT Act was made in violation of the ruling of the court that was given in Aderuba's case. Also, because of the victory in Aderuba's case, many states began to enact taxation laws in such a way that the situation in Aderuba's case became the same situation in AG Lagos and Eko hotels. In this particular case, Eko hotels were ab initio paying 5% of their profit to the federal government as VAT in line with the VAT Act. However, in 1995, the Lagos state government passed their own tax law. And in 2000, Eko hotels were approached by the Lagos state government to also pay that same 5% to them. So Eko Hotel at this point were reluctant to pay both the federal government and the state government 5%, which will make it 10%. What they did was to file a third-party proceeding, an interpleader, suing both the federal government and the Lagos state government to court. And the outcome of the suit will determine who they pay that particular 5%. Both the trial court, the Court of Appeal, and the Supreme Court, rejecting the authority of Aderuba's case, held in favor of the federal government that the state government do not have power to make a law that will levy tax on the same item that is the subject of taxation of the federal government. So not long after the Eco Hotels case, the Rivers State government also decided to test their own waters. This time around, they did not even rely on the authority of Aberuba's case, which talks about inter and intrastate rules, creating a dichotomy between the powers of federal government to levy tax and state government. This time around, they they challenged the powers of the federal government to levy VAT simpliciter. They argued that by the provisions of paragraph 58 and 59 of the exclusive legislative list, the powers of the federal government to levy tax are restricted to the items listed under those particular paragraphs. And the federal government does not have the power to levy tax outside those particular paragraphs. And since VAT does not fall under, or since VAT was not specifically mentioned by those particular paragraphs, that means the federal government do not have the power to levy value added tax. However, it was argued on behalf of the federal government by the learned Attorney General of the Federation that the powers of the federal government is not just restricted to the exclusive legislative list. The federal government also have power to legislate in regards to items included in the concurrent legislative list. However, it is my opinion that his arguments are defective in the sense that even the value added tax itself was not specifically mentioned in the concurrent legislative list so as to give the federal government powers to even legislate on it. So any item not listed under those two lists is residual to the state government. The Federal High Court, in giving judgment in favor of the Rivers State government, held that taxation laws are interpreted strictly. There is nothing like equity in taxation law. The judgment of the Federal High Court can be summarized into three standpoints. The first is that the federal government does not have power to levy VAT. The second is that VAT is a residual powers of the state government. And the third is that even the items under paragraph 59 and 50, paragraph 58 and 59 of the exclusive legislative list, which the federal government have powers to impose tax on. The FIRS is not the proper agent to impose those tax because by the provision of paragraph 7 and 8 of part 2 of the 1999 constitution, the federal government can only levy those tax through the state government and the bodies under the state government. So because of the outcome of this suit, the federal government appealed to the Court of Appeal, and almost the 36 state governments have filed their application before the court to be joined as respondent in that particular case, so that the outcome of the case will be applicable to the rest of the 36 states. Because if the Court of Appeal and the Supreme Court should uphold the judgment of the Federal High Court, it will mean that the state government will have exclusive powers. They will have unlimited control over the commercial activities in their jurisdiction. So everybody is quite anxious, and everybody is as well anticipating the judgment of the Court of Appeal with respect to this particular matter. Well, it is my opinion that since whoever wins, the money that is attached to the said judgment is still coming to the coffers of the Federal Republic of Nigeria, whether state government or federal government. So the best person with the best argument should win this case. So thank you for watching this video, and I hope this video has been very educative and as well interesting and entertaining. I urge our viewers to always comment on our videos, like, share, and also invite people to follow us both on YouTube and Facebook at Nigerian Law Documentary. Thank you.